Everybody. Welcome to the webinar today. And first, just wanted to thank everybody for taking some time to log on this morning to be a part of this conversation, particularly around the holidays. Really excited to have you all continue to be engaged with the Chamber and its programming. My name is Derek Seaver. I'm the President and CEO of the San Jose Chamber, and it's my pleasure today to welcome the team at Berliner Cohen, who is going to be leading us in this conversation today about upcoming employment law updates. So thank you from the team there for your willingness to do this. I'm going to introduce you all to your speakers this morning in just a second. But first, just a few housekeeping items. The first is, in just a moment, we are going to start recording this webinar. And the purpose of that is to be posted on our website later on for those members of the Chamber who aren't able to join us this morning, but want to make you all aware of that, that we are going to start that in just a moment. If anybody is uncomfortable without recording, wanted to give you an opportunity now to drop off, but we're going to start recording in a second. Also, all participants on the call will be muted and will remain muted until the question and answer portion, which is reserved for the last part of this webinar. And then we would also ask everybody that if you could, just for ease of the question and answer period, to write any questions that you have in the chat box. And I think Monique will also be facilitating some verbal Q&A towards the end as well. So with that wraps up our housekeeping items. We want to make sure we have plenty of time for this conversation. So I want to introduce you all to your two speakers today. The first is Susan Bishop, a partner at Berliner Cohen. Susan advises clients in a wide range of industries, including high-tech, franchisees, general contractors and subcontractors, homeowners associations, physicians and medical professionals, restaurants, beauty salons, sanitation, senior living, and temporary help agencies. Really getting a good cross-section of chamber membership there. Much of her time is spent defending individual and class actions, alleging meal and rest break violations, off-the-clock claims, unpaid overtime, and inaccurate wage statements. In addition, Susan is a San Jose native, is married and has 3 children, including twins. And as the father of just one, congratulations to you on that, Susan. Thank you so much for you taking the time this morning to come join us. Also want to introduce you all to our other discussion lead this morning, Eileen Kennedy, a senior attorney at Berliner Cohen. Welcome, Eileen. Eileen has over 15 years of litigation experience defending companies and individual managers in employment-related and other business disputes. She also represents a wide variety of employers, including companies in the food, beverage, and hospitality industries, senior care homes, property management businesses, medical and professional services, as well as families who hire household companions and caretakers. Eileen enjoys spending time outdoors with her husband and her 2 children. So Eileen, welcome. Susan, welcome. I want to thank you both again for being here this morning. And with that, I'm going to turn it over to you to lead the conversation for the next 30 minutes or so. So welcome to you both.
Thank you so much, Derek. I appreciate it. We're happy to be here. I want to make one statement, though, a new change to the background on Eileen. She's actually effective January 1st, Berliner Cohen's newest partner. So that's very exciting. So good times for
Congratulations, Eileen. We'll make that update next. We'll make that update next time. So.
yeah.
Thank you.
The first to know. The first to
Duly
know.
noted.
So, well earned. So anyhow, okay. So like everything with 2021. Things are changing on a regular basis. So yesterday, when we finalized this presentation, we thought we were good to go. But of course, my first thing I'm going to let you know is a new change that just happened. I just learned about yesterday afternoon, and that is the new requirement starting tomorrow that everyone indoors has to wear masks. And so that's new starting tomorrow, and it goes through January 15th. So I think the idea is California is trying to see what we can do to reduce COVID cases throughout the holidays. So all employers, now for us in Santa Clara County, which I'm in Santa Clara County, it doesn't really change much because we already have to wear masks. But if you're outside of Santa Clara County and one of those counties that didn't have to wear masks, starting tomorrow, you do. Okay, so I just want to let you know that's not on the slide because that just made it last night. Okay, so we're going to go through a bunch of new laws that are going to become effective January 2022. But what we're finding is that people still have questions sort of where we are with the COVID stuff. There have been so many changes in the laws. So I'm going to spend a few minutes just kind of a big picture view of where we are with COVID, but feel free to ask questions. Like Derek said, chat's fine. We'll spend some time after if you'd like with questions, but okay. Big picture where we are. As of right now, the FFCRA rule, the one that gave employees 80 hours of paid sick time if they had COVID, that has expired. That is, so that's no longer an obligation of employers to have to provide that. Along with that, though, of course, is the tax credit also expired. You might remember last year, there was a voluntary portion of this. So the law expired last year, but employers could continue on and still get the tax credit. All of that is over for now. Okay, we also in California had our California supplemental paid sick leave law, and that required certain employers to provide paid sick leave. That has also expired. That was the 80 hours, and that was designed for California wanted to kind of provide sick leave to those employees who weren't covered by the FFCRA somehow or another. So all of those are expired. Nothing on the horizon that I've seen. I'm sure there are talks, but nothing imminent. The one thing that is sort of, that has been imminent is the new OSHA, Occupational Safety and Health Administration's vaccine or test rule. Some of you may recall that would have required companies with 100 or more employees to determine which workers were vaccinated, which were not. And that was going to be a big change. That was a nationwide new law that was supposed to go into effect January of 2022. However, for better or for worse, that has been stayed. Now there's been litigation to say that the OSHA rules are unlawful for a variety of reasons. So as of now, it's been stayed. The expectation and all the kind of legal blogs is that it will be a while before this would go into effect, if it ever does. So I think it's going to have to go to the United States Supreme Court. So it will be a while. We don't have to worry about that right now. Some of you are in cities that might have had some local paid sick leave requirements for COVID-related absences. If we go, some of those have expired and some of those have not. For example, and Eileen, if you can go to the next page. These are some of the cities that have these local sick leave rules that are in addition to our regular California 3 days. This was in addition to. Many of them have expired. For example, in San Jose, this sick leave, this additional sick leave has expired. However, a lot of the city rules say that the sick leave program expires when the emergency orders of the city end. And in many cities that has an end, I think most cities. So if you're in a city that has a local, you're going to want to kind of keep up with that. Ask your lawyer or look on the city's website to see if those are still around. Okay, so what's left? I told you all the things that we don't have anymore. So what's left? Okay, so what's left for us? The big thing, of course, we have these public health orders. One of them, like I mentioned earlier, you know, some of the sort of general rules that we have, and I mentioned the California rule that's going to be in effect tomorrow. Someone in the chat said that, oh, okay, the mask mandate, if anyone's wondering about information, that is in the chat box now about where you could find more specific information about the new indoor mask mandate for California. Okay, but the big one that I want to talk about is what's still left over and what I think a lot of people and a lot of businesses weren't talking about last year, which was California's emergency temporary standards regulations. These are through OSHA. And these really are designed, these are for all employers in California, and they set forth a lot of rules for employers to address, try to prevent COVID, the spread of COVID, and address it when it happens. Go to the next slide. Okay. At the end of 2020, the Cal OSHA implemented these temporary requirements, and they were pretty strict. They were loosened in June of 2021, but nothing has really changed significantly since June of 2021. So if you were on it and have taken care of everything since then, you're probably okay. But what I find for a lot of the employers that I have, there's still questions, mostly because if you're an employer who hasn't had a COVID test or a positive result, COVID test in your workplace, you haven't really thought too much about it. But there are requirements, even if you haven't had even had people test positive, there are requirements to have a written COVID-19 prevention program that evaluates the employee exposures. It has policies and procedures to address working conditions. So that if you don't have it already, that's something that you as an employer are supposed to have. We can help you with that. There are also a lot of templates online that we can help you find as well. But the biggest thing that to me, has to do with what you do. Number one, if someone tests positive for COVID, these rules outline what to do. Number two, what to do, probably more important, what to do if you have a situation where someone tests positive in the workplace and you have employees who are potentially exposed, maybe have come into close contact with that person. How do you handle that? The biggest sort of non-commonsensical, I think, part of these requirements is that if someone is exposed to COVID-19 in the workplace or out of the workplace, there are certain things that a business has to do. Let me say first, COVID, if someone tests positive for COVID in the workplace, I think we have all of that covered. But if not, obviously that person has to be quarantined for a period of time. And that person, if they're exposed at work, can file a claim for workers' compensation. If they're not exposed at work, they could apply for state disability, and depending on their illness, may be eligible for state disability as well. So we kind of have that, I think, down. What we're talking about now are people who are exposed. And those are people who are defined as close contacts with someone who tested positive. And that means someone within 6 feet of a COVID case for 15 minutes or longer within 24 hours during the high risk exposure period, essentially when the COVID positive person was most contagious, which is 2 days before symptoms and 10 days after. So here are the things to note. If someone has been exposed to work, you want to identify those people. If they have been exposed at work, you want to identify them. If they are vaccinated and have no symptoms, there's nothing that an employer has to do. Just continue to monitor, make sure there aren't symptoms, etc. However, if someone is non-vaccinated and has been exposed to COVID-19 in the workplace, then that person needs to be excluded from the workplace. And if that exposure was just work-related, that person also has to be paid the regular wages during the time they're excluded from the workplace. And so that can be significant. That can be, in most cases, 10 days So you have someone who tests positive, you have someone who was in close contact with them who's not vaccinated, they have to be excluded and paid for their 10 days at least. Very different if someone's vaccinated or non-vaccinated. If someone is exposed to COVID-19 but it's not work related, then they still need to be excluded from the workplace, but the employer is not required to pay this exclusion pay. And so it's really important to try to figure out how someone was exposed, if someone was exposed, and also to know if someone is vaccinated or not vaccinated. That's going to make a big difference in going forward. Okay. It's funny, I did this talk the other day and I had so many questions on that, and now we have no questions on that. So, okay, so let's keep going forward. The California Department of Industrial Relations, dir.ca.gov, has actually a great website on the requirements for this emergency temporary standard, the ETS requirements. So if you do have questions, obviously call your lawyers, but also look to the DIR website. Okay. Just a couple of things I just want to make a quick mention of, and hopefully you've already been doing that, but you still need to document the status of the vaccination status of your employees. If they are not wearing a mask, well, now everyone's going to be wearing a mask, even for a short period of time anyhow. But otherwise, the ETS rules state that if someone is not vaccinated and they're in the workplace, then they typically are going to be wearing a mask. And so obviously it doesn't matter if they're vaccinated or not for the next month, but after that, we'll go back to what we've been doing for the last few months. Okay. Contrary to popular belief, the emergency temporary standards don't have a physical distancing requirement any longer, unless there's a major outbreak or a hazard. So there is no requirement to be 6 feet apart, although it is certainly still recommended. I don't like to just read everything that I have in my PowerPoint, so I'm just kind of going to hit the highlights. So Eileen, we pass to the next one. Next slide. Just a reminder, under these standards, if an employee has not been fully vaccinated and they have symptoms, they must be offered testing by their employer. The employer must pay for that, pay for the testing, and under the California Labor Commissioner's guidance, they also must be paid for the time it takes to go get the testing, which is why a lot of companies, I think, are trying to get testing in-house so that they can avoid that additional expense. But either way, an employer is responsible for paying for that. Okay, all right, let's keep going on that. Just a reminder that every single COVID positive test must be documented somehow. If it's just a test and the person does not have a severe illness, it's not bad, symptomless or not a lot of symptoms, you're going to document it on your, I'm blanking on the name, the L30, what's it called? I'm just blanking on this right now. Wherever you write, your log 300, your OSHA log, where you log any kind of injuries or accidents. So you're going to want to log it there. You're also going to want to notify your workers' comp insurance that there is a positive test in the workplace. They just want to know that initially for statistical purposes, the name of the person doesn't have to be stated initially, but they want to know for statistical purposes. If there is a serious illness, then you're going to want to contact OSHA and let them know what's going on if there is something serious in the workplace. And then at any time, if there are 3 positive COVID-19 tests in the workplace, you're going to report that to the local health department. Anytime when there's 3 or more within a 14-day period. So that's the look period, 14 days. If that happens, there's 3 or more, all employees can be tested for free of charge. It must be allowed during the work hours and be paid. The employees must be paid to take the test. And then if you're at that situation with multiple tests, multiple positive tests, you're going to require mask wearing again. Okay. Just a side note and a reminder that workers' compensation may cover time off for someone who's exposed to or gets COVID from and it's work related. There is a coordination of those kinds of benefits. I won't go too into the details, but it is important to note that wages can be supplemented if the employee wants that kind of supplement of their wages, because workers' comp does not cover everything. Just want to make that known. Okay, want to keep going. And I just wanted to finally just have another reminder about record keeping. All COVID cases must be recorded. The information should be confidential, but records must be made available as needed if there are requests. The records must be made available to employees representatives, and is otherwise required by law. That's what the records say. But again, it's just statistical information about testing. It's not specific information about the employees. One of the things I point out here is the penalties for non-compliance. There hasn't been, initially we didn't see a lot of penalties, but now they're starting to increase because I think the agencies are saying, hey, look, we've had plenty of time to get this in order. Under the new law, if it goes into effect, the OSHA law that is currently stayed, just wanted to make mention, a penalty for violating the rules if that new law goes into effect is 13,000, could be up to 13,653 for an initial violation, and you can see 136,000 for repeated violations. Now, not to scare anyone too much, this is if the new law goes into effect, but our own Cal OSHA also has the ability to assess penalties as well. Okay, now on to Eileen to talk about anything other than COVID.
Thanks. So I think, of course, COVID looms large still for most employers, but it's super important for everyone to remember that there were a lot of other laws that were passed, and we want you focused on them. So one of the major changes that occurred last year in California is sweeping changes to the California Family Rights Act. It again has gone through some revisions in 2022, so I want to mention again what the changes were last year, and then note what the new ones are this year, and encourage all of those people who are attending here to make sure you update again your medical leave or California Family Rights Leave policy. So as you might recall previously, the California law required applied to those employers who have 50 or more employees. That was significantly expanded to apply to employers that have 5 or more employees. So pretty much touching most employers in the state. The definition of child was going to include all children regardless of age. Key employee exclusion is eliminated. If you remember, under the Family Medical Leave Act, they kind of had regulations that specifically included a key employee, and also California applied that rule prior to 2021. That rule was for those individuals who are paid at the top 10% of the workforce. And the rule was that while those employees could have unpaid leave, it wasn't an obligation of the employer to return them after that leave. You had to go through a couple of processes, like identify the key employee and let them know that there's a potential problem that they may not be returned to work. And of course, that had to impact the workplace in a significant way. That exclusion or that exception is not available under California law. Parents from the same employer may take new child bonding leave at the same time. Family members for whom an employee may take family medical leave expanded to include grandparents, grandchildren, siblings, and parents-in-law. So that is the new change, and you want to make sure that you're updating the policies to cover that. A couple of other things to note. It's important to realize that family medical leave and California Family Rights Act leave overlap each other in many significant ways, but not entirely. So you could be in a situation where the same employee gets 12 weeks off under California Family Rights Leave, as well as 12 weeks off under Family Medical Leave. An example of that might be if an employee has to take care of a grandparent that has a serious illness, they could apply for unpaid leave under California law. And then in the same year, they might also have a spouse or a child that has a serious illness and apply for unpaid leave under Family Medical Act leave. So it's possible. It requires diligence on the part of your HR personnel to really focus in on what the reasons are, document what those reasons are, and make sure that you're designating the leave appropriately when an employee requests it. Other things that come up sometimes for our clients are, well, it's unpaid leave, but what pay might be available to employees? California law has, first, of course, there are your normal paid benefits, some of which may apply, others may not, depending on the circumstances. And in addition to that, there are wage replacement benefits that we pay taxes into, and they are administered by the Employment Development Department in California. An example of that would be paid family leave benefits, which are available for up to 8 weeks for caring for a family member who has a serious illness, and or bonding leave. So, and then also there's state disability insurance for employees' own personal disability. So keep those things in mind as you're looking through your policies to put them in effect next year. Please make changes to the California Family Rights Act policy that you have in place. Posting requirements for leave laws. Both California and federal family medical leave laws and California pregnancy disability leave laws require employers to post specific notices to employees in an area where those employees frequently visit. Written policies must be updated to include the changes in the law between 2021 and 2022. If you haven't done that already for 2021, please focus on that and then make sure you're compliant with 2022. Oops, I'm skipping, sorry. Okay, significant changes to meal and rest break premium rate of pay. First, what this context is. This is the context of those employers out there who have lots of non-exempt employees. As you all know, there are California meal and rest break requirements. They are strictly enforced, and they are often subject to class actions or a special kind of collective action in California called the Private Attorney General Act or PAGA Act collective action. Those are actions that are formidable, difficult to deal with, costly to defend. They carry significant penalties, and they are different than when a single employee sues the employer. It could be a single employee, and these types of collective actions, it could be a single employee suing on behalf of several employees who are either similarly situated in class actions or in PAGA actions, also aggrieved. Okay, so typically class actions and PAGA actions do carry a violation or a claim of a violation of meal breaks and rest break policies. So this is very important for everyone on this line who has non-exempt employees to pay attention to. You need to check with your payroll service to make sure that when a meal or a rest break is missed, that premium pay, number one, is being paid, and number two, is being paid properly. And this is one of the significant changes from 2021, which will carry on, has immediate effect, and will carry on into 2022 and beyond. When you pay the premium pay for a missed meal or rest break, you have to make sure that you are calculating the individual's regular rate of pay. And frequently employers think that perhaps, well, the regular rate of pay is just their normal hourly rate. but that is not exactly what the regular rate is. The regular rate of pay is defined pretty explicitly and with many examples, and it must be technically followed in federal regulations, which California law has also adopted. One of the very significant areas where I see lots of mistakes, I'm sure Susan does and others in our department have seen with employers or clients of ours, is that they frequently overlook incentive pay. Incentive pay is different than a discretionary bonus. A discretionary bonus means that it's completely within the discretion of the employer whether to pay the bonus and the amount to pay. That is completely different than a program where you're paying your employees to perform and you're promising perhaps a target bonus if they meet certain milestones. That type of bonus or incentive pay, that has to be calculated in the regular rate of pay. And that is exactly what this case was talking about, Farah versus Hollywood Hotel. So please check with your payroll company to make sure, number one, you're paying those premiums when meal breaks are missed and rest breaks are missed, and number two, that you're paying them properly. Extremely significant case came down also this year. It was decided by the California Supreme Court, so that means this is definitive. Donahue versus AMN Services, it prohibits employers in California throughout the state from rounding meal breaks. So you cannot change the practice of rounding meal break time punches so as to adjust the hours that the employee is actually working. That's the first significant decision that came down from the California Supreme Court in Donahue. The second is that time records showing in non-compliant meal breaks raise a rebuttable presumption of meal break violations, including at the stage of summary judgment, which is a proceeding that defending lawyers on behalf of employers tend to bring to try to cut off the litigation as soon as possible. If your time records are showing non-compliant meal breaks, it makes winning on summary judgment all the more difficult, now likely impossible, given the Donahue decision. Here's the takeaway from a practical perspective. Do not round any meal breaks. That means that if an employee is punching in 29 or 20 minutes for a meal break, basically punching in and out, but the entire period of time for the meal break is only 28 minutes or only 29, that's a violation of California law. You can't round up to 30 minutes. The rule applies retroactively. It was an interpretation by the California Supreme Court of existing law. The employer has an opportunity to overcome the problems with their time records with evidence of relief from the duty or the payment of the meal break premiums. There is a duty to provide an opportunity to afford meal breaks and rest breaks under California law. It's very clear you don't have to police it, but you should be looking at those time records and asking those employees, why did you only take 28 minutes or 29 minutes? Or maybe readjust your break period, make it longer than 30 minutes so you're avoiding that particular issue. Also, if they're missing one, why is there not a meal break appearing on the time record? Talk to that employee every single period and have it explained. It should be the manager or somebody who understands whether or not, in fact, that person just missed a punch or whether they didn't get a punch, in which case a premium is due. There's a narrow exception, which I won't spend a lot of time on, and applies only to security officers who are covered by a collective bargaining act and under the Private Security Services Act. This is a change from law which allows a security officer to have an on-duty break. This is very narrow. By and large, the vast majority of employers in California are not permitted to offer on-duty meal breaks or rest breaks to its employees. They have to be completely off-duty, have the ability to leave the workplace, and use that time freely as they see fit. Best practices: determine whether an employee is entitled to a meal break or a rest break premium. Look back and see if you properly paid your employees. Do it now. Do it as soon as you can. And if you see problems, either talk to a lawyer about how you want to go about fixing them, and don't ignore it. Do not round meal periods. Change that program if you have it right now immediately. Have policies and practices that notify employees of the availability of timely, uninterrupted, and complete meal and rest periods. Discourage employees from working through rest breaks and work periods, and never allow employees to skip that meal break so that they can leave early. Those are policies that will get you in trouble. Okay, this is an interesting case. I want to say that initially it came down, it was published, and it clarified something that sometimes is a dispute, and that is, how do you calculate overtime when you have a person who's working and they have two different rates of pay? California has long recognized that you take the weighted average. So basically, you take the total compensation in that pay period, and you divide by the total number of hours worked, and you come up with a regular rate of pay from which you determine the overtime premium. That is one method. It's recognized as acceptable. But there's another method that it appears in the California Labor Commissioner's manual, and that is that you can pay overtime for different types of work, so at different rates. And if the person is working overtime under one type of work, you can apply whatever the hourly rate is for that type of work, and then use that as the overtime calculation. Levinoff versus Dragas originally said that. It was a published decision. After a couple of weeks, it got depublished. I'm not sure what that will mean for the trend, but I do see that California is starting to recognize that there are two different rates, two different ways of calculating overtime. And if you have that rate in effect overtime premium calculation, you might want to check in with counsel and see if this is still a good place to go and to continue to do it. It looks like Levinoff versus Dragas is indicating that it is. Extremely important for those who are in business and they are changing businesses. They are maybe they are buying and selling, and especially for those closely held businesses. So if you're out there in attendance today, keep this new law in mind. There's an expansion of successor liability for labor code judgments. So if a prior entity had a judgment against it for failure to pay wages, the successor to that entity is liable for paying off that judgment. So that is not typical in buy-sell arrangements. Typically, the successor is not going to be liable if it's an arm's length transaction. There's consideration for that buy-sell for any of the liabilities of the former entity. This is a significant change in the law for California, because with respect to wage judgments, it's not. A successor is defined very specifically in this law. It involves closely held companies. It involves a buy-sell arrangement where most of the workforce will remain the same. The type of business will remain the same. The place of the business will remain the same. So if you're in this situation, it's important to confer with your counsel. You should be represented in any buy-sell. You need to confer with your counsel about this specific new law. In addition to that, if there is an outstanding judgment, there are new regulations regarding how you complete the statement of information that gets filed with the Secretary of State for California. So please note those. New record-keeping requirements, another really important law. It's a small one, but important. Remember that you have now 4 years. You need to keep personnel records for 4 years from the date they were created, and records relating to hiring, applications, any hiring notes or things that you had with respect to that 4 years from the date that the applicant did not receive the job. Employers have a statutory duty to preserve all relevant records if they receive a notice of a claim until the later of the resolution of that claim or the expiration of the statute of limitations related to that claim. Statute of limitations is a technical legal term, which means after a certain period of time, you can no longer sue on that claim. Additionally, the Department of Employment and Housing, this is the agency in California which regulates and enforces discrimination and harassment, unlawful discrimination and harassment laws in the state. They have a deadline to complete its investigation. If they are investigating a claim, there's now a tolling period. And specifically with those discrimination complaints that are treated as class or representative actions, it's extended for 2 years and claims are tolled for those 2 years. So I think the takeaway from this is if you are aware of a claim or a threat of unlawful harassment or discrimination, your best practice here is to investigate as soon as possible, because it can be a long time before that claim, if it does wind up in litigation, begins that litigation. So that's one thing that you should keep in mind as these things come up in employment. Extremely important, non-disclosure and confidentiality and separation agreements. In settlement agreements, it's prohibited to include a non-disclosure provision in a settlement agreement for acts of sexual harassment. That was imposed or enacted in California back in the time of Me Too. That has now been expanded to include all acts of workplace harassment, whether they are based on any other protected category. Non-disclosure provisions and agreements. There are greater limits on non-disclosure agreements for current and departing employees, to include limits on the right to disclose all unlawful acts in the workplace, including any act of unlawful harassment or discrimination. So there's a new language that would be required in a separation agreement, for example, where you're asking for that release or that non-disclosure of confidentiality of information. The new language is posted here in this slide. I won't repeat it for you. There are new notice requirements for separation agreements. Separation agreements for those individuals who are under 40 years old. You probably, if you have asked for a separation agreement or offered a separation agreement to those individuals, you've probably been told by your attorney there's no real notice requirement, but we like you to give reasonable notice. Well, now there is a notice requirement, and that is 5 business days before you can require that individual to sign that agreement. Okay, so what does this mean? If you have a separation agreement that you're using on your own that had maybe been previously vetted by counsel, it's now time to update that with counsel. No rehire provisions. Waiver of future employment clause means that a plaintiff cannot reapply for any positions with the employer, and the employer does not have a duty to rehire the plaintiff. There's this very restricted type of provision. If you are using these types of provisions again in your separation agreement, again, it's time to speak with counsel to make sure that this is compliant with current law. PAGA. So PAGA I described before, and I wanted to point out because it's an ongoing, well, I should start with this. I'm reading reports that PAGA filings are up by 1,000%. So that's a scary number, and we want the folks who are participating in this call to understand that what triggers it so that you can jump on it immediately. You should be receiving a copy of a letter that's addressed not to you, but to the Labor Workforce Development Agency if one or more of your employees is going to threaten a PAGA action against you. What you should know is that a lawsuit is likely going to follow, likely within 2 months or so of receiving a copy of that letter. So what you should do is contact counsel immediately. Sometimes the alleged violations can be cured, but there's a time limit for doing that. There's a 30-day time limit for doing that. So contacting your counsel immediately will help you potentially cure it if it's possible, allowable under the law. And it also will help you assess the violations and your defenses immediately so you can start to prepare for that lawsuit. One good thing, we'd like to show a few winning cases. One is Wessons versus Staples. In this case, this PAGA claim was considered unmanageable by the court. So there are some defenses out there. It's not all doom and gloom with respect to PAGA. And this is an example of one of those cases that worked well for an employer. Audits are on an uptick now. I think the enormous number of unemployment claims have triggered the Employment Development Department in California, which manages those unemployment claims, to start to begin to audit. We want you to please review. If you're treating anyone as an independent contractor, take another look at that. Make sure that you are properly classifying that individual. If you have questions, reach out to counsel. There have been significant changes in the past couple of years in that area. I am going a little quickly here because I want to leave at least a couple of minutes for questions. We have a couple of other cases that are good to mention. One is Santos. It was UPS won a victory on class certification, which is wonderful. That means that if you do not have a class that's certified, you are back down to one plaintiff, a much more manageable type of lawsuit to either settle or defend against. The court held that the UPS's timekeeping system is not inaccurate or inadequate simply because it does not require employees to record their rest periods. That's still the law across California. You need not record that particular break. Different from meal breaks. Keep that in mind. And again, the Magna versus Walmart was a pretty complicated case, lots of different holdings, but one of the good takeaways is that an employee in this case made a lump sum payment to cover overtime premiums for incentive pay arrangement that was paid on a quarterly basis. And they did so looking back over the entire quarter, paid it in one lump sum. The complaint against Walmart was that they should have designated the different hourly rates and time periods for which that lump sum covered. The court wound up ruling that the pay stub was fine. And this is very, very important. Mandatory arbitration agreements are, of course, very common in California now and often recommended because you can avoid a class action at least if you have a mandatory arbitration agreement. But in 2019, California legislature recognized that this is not good for employees, and they wound up passing AB 51, which made it unlawful for employers to require that applicants or employees sign arbitration agreements. A federal district court preliminarily enjoined AB 51 2 days before that law was scheduled to go into effect. And recently, the Ninth Circuit partially vacated that injunction. So as of today, the portion of AB 51 that makes mandatory arbitration agreements unlawful has been determined to be valid and enforceable in California. So the recommendation is currently make those arbitration agreements voluntary. We have a chart at the end of this slide, and it's a handy little chart to help you keep track of minimum wage increases. So this slide deck should have been sent around. And with that, I have no further slides for you.
We had a couple questions in the chat box, which I have answered regarding meal and meal breaks, and whether or not there's a about the timing of meal breaks and whether or not a meal break that occurs after the end of the 5th hour is subject to a meal break premium. And the answer is 100% yes. A late meal break is the same as not taking a meal break according to the law. Okay, someone's asked about the minimum wage increase slide again. Eileen, you want to go back, that's fine, but also please note that all these slides are going to be sent to all of you, and it'll have this chart on it. So you'll have it today for sure. So you don't need
Yeah,
to-
there are three slides on minimum wage, so I'm not sure which city you need to see, but you'll get it anyway. If you put it in the chat, I can stay on that minimum slide.
Okay, and then I have one other question that I see. We are a restaurant group. My employee takes the meal break as he comes into his shifts. Is it a compliant break if an employee doesn't work 30 to 60 minutes prior to the meal break? Okay, so I think what you're saying is you have someone starting at 9 a.m. their shift, and you have their meal break at 9 a.m. and then they don't start working until, they don't actually work until 9:30. That's not really a meal break. That's just having someone start at 9:30. I don't think that the law is going to go for that. It's supposed to be in as middle of the shift as possible, but before the end of the 5th hour. However, the law is clear that you can have early meal breaks. So maybe an hour or two in, maybe 2 hours in, 3 hours in would be fine. Eileen, maybe you feel differently. I haven't seen a case on it, but I can't see a court saying, oh, you took your meal break at, from 9 to 9:30 before you had even started working. I think any court's going to see that that's a way to actually not provide the meal break. And that's not going to be considered a compliant meal break.
Right, you're gonna want to see your time records are now critically important given the recent case law. So you're gonna want to see a punch in, and there should be working for a period of time, and then a punch out for that meal break. You know, I get in the restaurant industry, it's extremely difficult because you typically are taking meals, but your restaurant workers are working. They need to work at that, that busy time. So you just have to try to fit them in the morning, but not immediately when they report for work.
The earliest I think I've seen that's been fine is maybe 2 hours after they've come into work. But definitely not before they've even started working. That's just not a meal break. So, yeah, I don't see any other questions. If anyone has any, let us know. Otherwise, let's see if there's anything in the chat. If something comes up after and you want to ask a question, let us know. We're around. You have our email addresses and all of that. I don't know, Derek, if you want to say any final words or not.
No final words other than to say thank you to the both of you for leading the conversation. Thanks again for everybody for logging on, and hope everybody has a wonderful holiday season.
All right. Thank you so
Derek.
much. Happy holidays.
Thank you all. You too.
Thank you very much. Take care, everyone.
Bye.